Case summary. Felthouse v. Bindley, 1862, is a landmark English contract law case that established important principles regarding offer and acceptance, specifically the notion that silence cannot constitute acceptance of an offer. This case is frequently cited in discussions of contract formation and remains a cornerstone of contract law. Background facts. Claimant, plaintiff, Paul Felthouse, an uncle who wished to buy a horse from his nephew. Defendant, Bindley, an auctioneer. Third party, John Felthouse, the nephew who owned the horse. Paul Felthouse, the claimant, was negotiating with his nephew, John Felthouse, to purchase a horse. In a letter dated January 2, Paul Felthouse offered to buy the horse for £30.15 and mentioned, "If I hear no more about him, I consider the horse mine at £30.15. The nephew, John Felthouse, did not respond to this specific letter, thereby implying his assent. However, there was no formal communication of acceptance from John to Paul. Meanwhile, the horse was mistakenly sold by Bindley, the auctioneer, at an auction where John's other farm stock was being sold. Argument. Claimant's argument. Paul Felthouse argued that there was a valid contract for the sale of the horse because he had made an offer and, by the terms of his letter, he interpreted his nephew's silence as acceptance. Defendant's argument. Bindley, the auctioneer, contended that no valid contract existed between Paul Felthouse and his nephew because there was no communication of acceptance from the nephew. As such, the sale of the horse at the auction was not wrongful. Final outcome and legal justification. Outcome. The court ruled in favor of Bindley, the auctioneer, concluding that there was no valid contract between Paul Felthouse and his nephew. The justification was that there was no communication of acceptance from the nephew to the uncle. Silence cannot constitute acceptance in the context of forming a contract. Legal justification. 1. Offer and acceptance. A fundamental principle in contract law is that acceptance of an offer must be communicated to the offeror. Silence, in the absence of a clear agreement that it shall constitute acceptance, cannot be treated as such. 2. Communication of acceptance. The law requires that for an acceptance to be effective, it must be communicated to the offeror. In this case, John Felthouse's silence did not constitute acceptance of Paul Felthouse's offer. 5. Key concept. Implications and precedents. 1. Silence is acceptance. This case solidified the principle that silence does not amount to acceptance in contract law. A valid contract requires a clear communication of acceptance. 2. Relevant case. This case is often discussed alongside cases like Entorslet v. Miles Far East Corporation, 1955, which further emphasizes the need for acceptance to be communicated. 3. Learning point. Candidates should understand that for a contract to be binding, there must be a clear offer and an unequivocal acceptance that is communicated to the offeror. Silence, without prior agreement to treat it as acceptance, is insufficient to form a contract. This case teaches the importance of explicit communication in the formation of contracts and underscores the necessity for parties to clearly express their acceptance of an offer to avoid ambiguity and potential disputes.